12 News' legal analyst Dan Adams is joining us once again live this morning. Dan, thanks for your insight on this case. What kind of witnesses do you expect the defense to call?
Well, yesterday we saw the defense start their case with shorter witnesses who were fact witnesses, people who were around the shooting scene when it happened. Today, I imagine that we could see two things. We could see the defense's expert, use of force expert, a person who could explain whether or not, in his experience studying uses of force with firearms, whether or not Kyle Rittenhouse acted reasonably. And then, of course, the big witness in the case, who we've all been waiting for, is Kyle Rittenhouse himself. He could actually take the stand as early as today.
We'll be very interested to see if that happens. Now, Dan, one of the first witnesses the defense called directly contradicted a prosecution witness, what they told a jury last week. So someone at the car source said they did not ask for people to come for protection, but here's a little bit of testimony that kind of contradicts that.
He calls me in the morning of the 25th asking if I could provide assistance to watch over the building later in that night.
Okay, so again, one of the business owners, though, testified that that never happened. They never asked anyone to protect their business. So what about this conflicting testimony? How much does that impact a jury usually?
Well, why the vigilantes or the militiamen were at the car dealership in the first place is a question I'm sure the jury wants to know. And at this point, with the defense's witnesses, it's been muddled. I don't know if they're going to explain in closing arguments why the dealership owners would have made up a story about not calling the militiamen into their store. Perhaps some type of motive, maybe there's civil liability, maybe they just don't want to be associated with this shooting any longer. But certainly the waters on that minor issue are muddled.
Right, and I guess the question is, does it even really matter why they were there in the self-defense case? And, you know, we haven't seen much emotion from Rittenhouse throughout the trial. He's looked down a few times. He hasn't looked at maybe all the videos, but yesterday our cameras captured him laughing a little bit as the prosecution questioned the medical examiner. What impact does that have?
Well, as I tell my clients, the jury is always watching you. They're always assessing you. Even in the hallways of the courtroom, you have to act perfectly all the time, with an eye toward being evaluated and judged. A little laugh at an inappropriate time isn't good, but ultimately I expect Kyle Rittenhouse to testify, and that's when the jury's really going to take the pulse of him and see whether or not they think he's credible.
If he was your client, would you want him to take the stand?
That is the big question in this case. The defense attorney, Mark Richards, basically promised in opening statements that his client would testify in 95% of self-defense claim cases. The client does testify. However, this is a very unusual case with all of the video documentation. I'm going to see what this self-defense expert, if they put him on today, says, and whether they still feel the need to put Kyle Rittenhouse on the stand and be subject to cross-examination by the government.
Okay, Attorney Dan Adams, as we head into day 8 of the Kyle Rittenhouse trial. Thank you.